Hello viewers, welcome to our program on immigration and you. I am your immigration attorney Michael Fulwani, and once again we have with us my partner attorney David Nachman. David, welcome.
Thanks so much, Michael. Pleasure to be here.
In today's program, I think David wants to give you some information on the recent changes on the I-94 and also something about the I-9 and what are those two different forms. Let me explain you. I-94 is when you come, non-immigrants come in the plane, the air hostess or somebody gives you the form to fill up, and when you land at the port of entry, then the officer will, after deciding how much time should be given you to authorize the stay, he will stamp and give you a small white card that you generally keep in the passport. And that has been changed, that David is going to explain you what the change is. And I-9 is the form when an employer hires any person, he is required to fill up that, have that person fill up the I-9 form and give the documentation showing that he is permitted to work in the United States, maybe a citizen, maybe a green card holder, maybe some kind of work visas. With that, I want you to tell our viewers what these changes or importance are about both I-94 and I-9.
Okay, so I guess we'll start with the I-9 form. We mentioned it before on one of our previous programs, but just to mention it again, for any of you who are employers, every employer in the United States is required to fill out for every single employee what's called an I-9 form. An I-9 form is for employment verification. So every one of your employees should have an I-9 form filled out, and the I-9 form is something that the employer holds on to in their employment files. It basically tells the employer that the individual is authorized to work in the United States. It's important for you to hold on and to maintain these documents because the Immigration and Customs Enforcement officers are out there doing audits, and if you don't have I-9s, you could potentially get fined, and also the Immigration Customs Enforcement can bring penalties against you, and also allegations that you've engaged in the employment of unauthorized workers. So it's something that you need to be aware of as employers. So that's just an announcement for all of our employers, employer viewers. With regard to the I-94 document, the I-94, as Michael pointed out properly, is a document that you're given on the airplane, and I'm kind of thinking that maybe this is where you're running around on the airplane trying to find a pen to fill out the I-94. No one ever has a pen with them, so everybody borrows pens. I'm kind of thinking that maybe this is just because nobody had pens, so CBP decided, you know what, let's just get rid of these things. So what they're doing is they're getting rid of the I-94, but the I-94 does serve a purpose. For example, if you're a student, you need the I-94 because you're going to have to show it possibly to DMV, to Social Security. So here's the way the procedure.
Driver's license.
Right, for a driver's license, for a Social Security card. So here's the way it's going to work, is that you'll bring your passport. You'll have your passport swiped at the kiosk by Customs and Border Protection, which is something that's very normal for everyone. And then what will happen is you'll be given a stamp in the passport. What that stamp will have on it is an identifying number. And then what you'll do is you'll have an opportunity to go online to the website, type in that number, and you'll be able to print out your I-94. That way, for the people who don't need the I-94, they don't have to worry about it too much. But for the people who do need the I-94, they'll have access to it by printing it out for themselves. And of course, probably best practice will be always to identify that, in fact, the I-94 can be printed out, and to take a look at it to make sure that it was issued accurately. I can tell you from day-to-day experience that we do encounter clients whose I-94s, when they're given and placed in their passports, are not properly designated. And when that happens, we have to send the individual back to the port of entry and have it modified. So obviously the best practice will be that we will tell all our clients to print it out and to hold on to it and maintain it, just so, number one, they know when they have to leave, because you certainly don't want to find out that you overstayed a date certain on the I-94, because of course that has ramifications. So we're of course going to find out. It has not yet been announced in the Federal Register, but it's coming down the pike. Everybody sort of knows about it, and so I just wanted to make our viewers aware.
Okay, let's go back to the subject we talked on our previous program on comprehensive immigration reform. And one part of the comprehensive immigration reform that discussion is going on is the family reunification. Now, there have been some rumors, some information coming from some places that they should kind of eliminate the family third preference and the fourth preference, which are the married sons and daughters of U.S. citizens and brothers and sisters of U.S. citizens. I don't think it's very strongly, but this was raised as a result of which our Immigration Lawyers Association put in a big, brief on that, and some other organizations also have been opposing that kind of proposal. We don't want that to happen. It's ridiculous. I tell you why. I have the number. Only 9% of the total visa numbers go to these two categories. Very small number. But how many people will you be hurting? These are family members, family unification, especially in our communities, like people come from India, Pakistan, Bangladesh, Nepal. Our families are even Jewish people or even Italian people. By the way, this issue, I think it was Congressman Peter Rodino. Peter Rodino in the 80s, and I did some fundraising for him and I met him personally. That time also there was issue raised on eliminating the employment, the family fifth preference used to be at that time. Mm-hmm. And he being, I think, chair of the Judiciary Committee, very strongly opposed because Italians have the same close familyness, and he killed that bill at all. So I don't think it may go forward, but it's a good idea to keep an eye. I mean, what they will do in the comprehensive immigration reform, sometimes they put in small print quietly things that could hurt. So we have to be very vigilant. Of course, David and me, we're looking every word, every line of the bill. We will see out of our association, and we will definitely raise that issue, tell you what they are doing. If at all something like that is coming forward, right, we need to oppose and we need to fight for those things. And we never let them do that, because a lot of our viewers, their brothers and sisters and daughters and sons and their families are waiting in line for years and years and years. Right. And that should not happen. That's unfair, I would say.
Exactly. No, I absolutely agree. I mean, I think that family unification and the issues of family separation are very important and will clearly be taken into account when they undertake the comprehensive immigration reform bill. I think that the family I think that I think that this is sort of politically motivated, and what we see going on right now are that Congress, they're having hearings with regard to the major issues that should be subsumed within this comprehensive immigration reform bill once that bill comes down, of course. So dealing with,
So the couple of changes, my suggestion, they may or may not be in the bill, but something like I would like to see is changing the age of the petitioner from 21 to 18. The 18 years they are permitted to participate in elections, 18-year-olds.
Right, yeah. Right? Well, you could vote at 18.
I remember one time used to be 21 and they changed to 18. Same principle should apply here. The 18-year-olds are, you say adult enough now to make that decision to call the parents or not, or the husband and wife or not, getting married. So I think that is an important thing, in my opinion, to happen. The other thing is that the permanent residence green card holders should be treated like U.S. citizens in terms of filing the petitions for their spouses and children. Listen, husband is a husband, wife is a wife. I always said, children are children. Look from the humanity point of view. Why should we differentiate between wife of a citizen and a wife of a green card holder, son or daughter? I mean, that's the other important change. And then the CSPA issue. I think when a petition is filed, let us say citizen or a green card holder who is filing a petition for the child. Okay, and actually citizens, if they are under 21, then it's an IR category. But when they are filing whether a child over 21 of a citizen or child over or even under 21 of a green card holder, that should freeze. They are included in that petition and to age out. So what? They are there, they file on that, and there have been some court cases, as a matter of fact, if you know, David, where the courts have said that they are also entitled to the priority date. I mean, the only thing the courts have said that once the I-130 petition is filed and he ages out and does not qualify under CSPA, and the parent who got the green card, he files a new petition for that aged out child, that petition should be given the same old priority date that the parent got. So in some way, I mean, now what are we seeing here now? Basically, the children that aged out and don't qualify under CSPA go under F2B category, or even F1 category for 5 years, 6 years. F2B category maybe 9, 10 years. Not fair. So these are some of the changes that I would say would be probably more important. And what are your comments on that?
Well, just quickly, Michael, I think that we seem to be, if we take a look at what the legislation is, we seem to be moving in the right direction. If you take a look at what came down on March 4th with regard to provisional waivers, there seems clearly to be an interest in reuniting families. And obviously the Obama administration has done what they can to push in that direction administratively. So we have stateside processing now of provisional waivers. We have the ability to reunite families faster than we did before. And that is a step in the right direction. Clearly, what they're doing, I guess, in a subtle way, is presenting legislation that is much more in favor of this reunification of family members. And I think that if we take a look at the Comprehensive Immigration Reform Bill that does end up taking shape, I think that we're going to see, as you rightfully point out, that they're going to deal with the moral issues of family members being separated, as opposed to the hard and fast rules that exist now in the law and in the prior immigration law.
I say whichever way you go, the way that I suggested, or the way that they can increase the quota, the visa numbers, make some changes, and a one-time allotment of visa numbers to clear all the backlogs in the brother-sister category or married sons and daughters. Something needs to be done to unite the families. Actually, it's the best thing to just clean the slate. Have all those cases and then you start a new right. slate with under the new law. And then the new line can start.
Yeah, I don't know if they're going to be in a position to be able to do that, because I think that there's going to be...
Republicans will probably not agree.
Yeah, they're not going to be thrilled with that. So obviously it's going to have to be some kind of a middle ground that they strike. But I'm sure that there probably is a way to do it. So again, I think what it is that, the law should be as close to what's morally correct as possible. And I think that that's where they should be striving for, is what is morally correct and what allows families to be together. I think that Michael and I, being immigration attorneys on a day-to-day basis and sitting with clients and hearing stories about where families are separated, it tugs at our heartstrings when a father or a mother can't be with their children in the United States. It's awful. And so obviously, I strongly encourage our legislators to really think hard about those issues.
And as I say, let us pray God and request God to help us in getting the bill passed. Absolutely. So that all your problems are solved. All your family members related waiting in India, Pakistan, Bangladesh, Absolutely. All other countries come and join you. So with that, we come to an end of the program. David, thank you very much for watching the program. And thank all
Michael.
of you for watching the program. Please make sure to watch us every Sunday morning, Vision Avesha at 11:45 a.m. and on ITV every Saturday at 7:45 p.m. Thank you.